Hello, ladies and gentlemen. I'm Julia Villamines, your librarian this term. Today we are joined with the Honourable Chief Justice Ma, the Chief Justice of the Hong Kong Court of Final Appeal. Over the last 2 decades, he has held various positions in the High Court of Hong Kong, including Chief Judge and Justice of Appeal. A staunch advocate of judicial impartiality, he has criticised judges who have expressed political opinions during recent protest movements, and is considered one of the most respected defenders of human rights in Hong Kong. He's going to be speaking on criticisms of the Hong Kong judiciary and their impact on the rule of law, after which we'll move on to questions from me and the audience. Chief Justice Ma, thank you so much for joining us. It is truly an honor.
Thank you very much, Julia, and hello to everybody who will be watching this. So I'm going to start off by, as Julia has mentioned, the title of this mini speech is Criticisms of the Hong Kong Judiciary and Their Impact on the Rule of Law. "You fools" was the headline in one of the popular newspapers in the United Kingdom in 1987, following the Spycatcher litigation, when the House of Lords upheld an injunction preventing the publication of the memoirs of a former MI5 agent when they had already been published in other countries. The headline accompanied upside-down photos of the law lords. You are also probably aware of the headline in another popular newspaper following the decision of the Divisional Court in the Brexit litigation in 2016. It read, "Enemies of the people," with some further unpleasant remarks directed at the judges. In a well-known decision by the Court of Appeal, which can be taken as the starting point in defining the form of contempt known as scandalizing the court, a journalist described the judge in a trial involving obscene libel as the impudent little man in horsehair, a microcosm of conceit and empty-headedness, and that the fact that the judge had benefited from a bequest by a wealthy relative, in quotes, spoiled a successful bus conductor. We are similarly not immune in Hong Kong. When decisions of the courts, particularly in criminal cases, have not produced the outcome to some people's liking, judges have been referred to in abusive terms. I have also been personally abused and doxed as well. In a sense, these are examples of criticisms made against judges, but they are perhaps more abusive criticisms than serious ones. However, of more concern in recent times has been the type of criticism that is made without any real basis other than a mere dissatisfaction with the outcome of a case. The criticism almost invariably involves accusations, direct and indirect, of judicial bias, and this of course goes to the heart of the judicial process, the independence of the judiciary, and ultimately to the rule of law itself. I confine myself to the position in Hong Kong, and here I must briefly set out the relevant context. As you know, last year and even before, Hong Kong experienced an unprecedented series of protests, and there was much violence to be seen, at times on a regular basis. Many arrests were made. Trials involving charges of assault, rioting, unlawful assembly, and so on have been coming up before the courts. In the judiciary, we call them SE cases, social event cases. As you know, in a criminal trial, there are 2 outcomes. The accused is found guilty or is acquitted. SE cases are often loaded with political tensions between those who support the protesters and those who do not. Politics can cause deep divisions and give rise to much controversy, often heated. So you can imagine the reactions and emotions that are generated when a trial results in a conviction or an acquittal. This is where the type of criticisms to which I have alluded come into the fore. It is often made not just by interest groups, but also by members of the public, politicians, the press, and even some lawyers. And when the origins of the case involve politics of whichever persuasion, the accusations then leveled against the judiciary becomes, as I've said, based on bias, and in particular, political bias. For me, this is of no small concern. Every community is entitled to expect and take for granted an independent judiciary. And when this is placed in doubt, the rule of law itself is undermined. The rule of law has two important connected components. There are other facets of it not necessary to discuss for present purposes. First, the rule of law recognizes the notion that not only that the law is there to govern the interrelationships and interactions between members of a community, but it is there also to protect individual rights and freedoms that define the integrity that should be accorded to people. This feature of the rule of law can be expressed as an acknowledgement of the rights of the individual, coupled with the respect for the rights of others in the community. Secondly, in order to enforce the law, as I've just described, the rule of law requires an independent judiciary. Now, what does the concept of the independence of the judiciary mean? It is crucial to understand at the outset that the concept does not involve the courts or their work being involved in politics. I will elaborate presently on the constitutional position in Hong Kong, but for the time being, it is important to understand that courts and judges discharge only judicial functions and do not involve themselves in politics, much less wield any form of political power. I've been talking so far about the importance of the rule of law. How does one go about testing it in any given jurisdiction, whether or not it exists? One starts, of course, by examining the legal infrastructure in place. For most jurisdictions, the starting point is the constitutional document that governs the community. In Hong Kong's case, our constitutional document is known as the Basic Law, which consists of 160 articles reflecting, as its preamble declares, the implementation of the basic policies of the People's Republic of China regarding Hong Kong. It is only by looking closely at the constitutional document that one can begin to assess whether characteristics of the rule of law have been guaranteed or preserved. It is important from a practical viewpoint to see whether such characteristics have been included, for they mark the blueprint of what a community can expect of its legal system. In short, they represent the fundamentals of any legal system. What are those characteristics of the rule of law? And using the example of Hong Kong, do they exist in constitutional documents? I've already made reference to the two most basic characteristics of the rule of law. First, the independence of the judiciary. It is important to bear this aspect firmly in mind, particularly when dealing with cases with social, economic, or political origins. A corollary of this is the fundamental tenet which the law demands universally: equality before the law. The independence of the judiciary is underlined in 3 separate articles of Hong Kong's Basic Law. Those who are interested, Articles 2, 19, and 85, refer to Hong Kong being vested with independent judicial power, such power to be exercised free from any interference. Article 25 of the Basic Law states the requirement of equality before the law. A practical manifestation of the independence of the judiciary is that judges are required to be completely apolitical in the discharge of their duties. This is not just desirable, it is a constitutional imperative. The duty of every judge is only and simply to administer the law. This means dealing with cases strictly in accordance with the law, with no extraneous factors such as politics influencing the result. There can be no question of bias. Arbitrariness and bias are the opposites of acting in accordance with the law. Were this not so, this would certainly impinge on the guarantee of equality before the law. Article 92 of the Basic Law states that judges in Hong Kong are chosen on the basis of their judicial and professional qualities, nothing else. Not to be forgotten either is the judicial oath which we all take, required to be taken by our judges. This requires judges to discharge their duties in full accordance with the law and to safeguard the law and administer justice without fear or favor, self-interest or deceit. The judicial oath taken by judges in your own jurisdictions will be to similar effect. The second fundamental characteristic is the respect for and protection of fundamental rights and freedoms. We are all familiar with the content of these rights and freedoms: the freedom of speech, of the press, the freedom of association, of assembly, of procession, of demonstration, freedom of conscience, the right of access to the courts, so on. These and other rights are not only expressly spelt out in the Basic Law, they are repeated in the important Article 39 of the Basic Law. This article provides that the International Covenant on Civil and Political Rights, the ICCPR, as applied to Hong Kong, shall remain in force and be implemented through the laws of Hong Kong. The ICCPR is implemented virtually word for word by the Hong Kong Bill of Rights Ordinance, which contains a Bill of Rights setting out the fundamental rights found in the ICCPR. The importance of Article 39 lies not only in the mere setting out of relevant rights, it introduces applicable international standards in relation to such rights. It is partly for this reason that reference is frequently made to decisions of the European Court of Human Rights on comparable provisions to those rights contained in the Bill of Rights. An analysis of the concept of the rule of law begins with, as I've just done, identifying the applicable legal infrastructure in any given community. However, just as important, if not more so, is the examination of whether those promises, often eloquently and forcibly set out in constitutional documents, are fulfilled in practice. This is the ultimate empirical test of how tangible the rule of law is in any jurisdiction. Part of this exercise involves looking at how the courts have in practice performed their constitutional duties. Here, the usual context in which to test theory against practice is the treatment of what are known as public law cases, because it is in this type of case where those facets of the independence of the judiciary and the enforcement of human rights most often take center stage. Particularly over the past 23 years following the 1st of July 1997, date when the People's Republic of China resumed its sovereignty over Hong Kong, Hong Kong has witnessed a far greater awareness by the community of fundamental rights and freedoms than before, resulting in a significant increase in the number of constitutional and administrative law cases handled by the courts. Most of such cases have, of course, involved the government as a party. In brief, I wish to highlight the following points that emerge from the decisions of the Hong Kong courts. First, a purposive and generous interpretation is to be given to fundamental rights and freedoms. This is because rights and freedoms have to be given real meaning in effect, this being the clear intention of the Basic Law. After all, the chapter of the Basic Law setting out rights and freedoms is headed Fundamental Rights and Duties of the Residents. Correspondingly, measures which seek to restrict or limit fundamental rights and freedoms are strictly construed. Secondly, the approach of the courts has often been to balance the various rights that collide against one another in any given case. For example, the freedom of opinion or expression is not without limits. As Article 16.3 of the Hong Kong Bill of Rights states, the exercise of the rights provided for in paragraph 2 of this article, that's the right of freedom of expression, carries with it special duties and responsibilities. It may therefore be subject to certain restrictions, but these shall only be such as are provided by law and are necessary for the respect of the rights and reputations of others, or for the protection of national security, or of public order, ordre public, or of public health or morals. It is important to see this balancing approach for what it is. The approach of the court is not to deny or sacrifice one right against another right. The objective of the court is to try to ensure that all rights are properly respected and acknowledged. This is part of the overall spirit of the law, in not just respect for individual rights and liberties, but also respect for the rights and liberties of others. At all times in the determination of cases before them, the courts will only apply the law. I've already emphasized this point, but it is worthwhile reiterating it. Even though the determination of rights involving fundamental rights and freedoms will often originate from political, economic, or social situations, the court's role is only to determine the legal issues by applying the law and nothing else. Political, economic, or social influences simply do not affect the outcome of cases. Only the proper application of the law does. These points I've just highlighted about the rule of law are at all times and without exception evident in the work of the courts in Hong Kong, but they are sometimes lost sight of when the result in cases, especially in high-profile ones, do not go the way that certain people or interest groups would wish. A further test by which to evaluate the rule of law is to see how transparent the legal system is in any jurisdiction. In Hong Kong, transparency is evident from two facets. First, all proceedings are open to the public. Secondly, the reasoning of the courts in arriving at any decision is also made public, so that the public can see precisely how a court has dealt with a case and whether it has done so strictly in accordance with the law. Of course, as far as the judiciary is concerned, transparency invites criticism in that there is simply more material to use in this respect. However, criticism, particularly if constructively made, is healthy and promotes progress and improvement. At its lowest, criticism is a part of free speech. Nevertheless, criticism should be made with a proper basis, and this is all the more important when serious criticisms are made. I started this talk by referring to allegations of bias leveled against Hong Kong judges. These are, of course, serious allegations, but if they are to be properly and rationally examined, it is imperative that a proper basis should be articulated. This is the least that can be expected. Otherwise, there is a risk of undermining confidence in the rule of law, and that is a risk none of us should be prepared to accept. Hong Kong's judiciary will continue to face challenges, just as I believe all judiciaries do, but the rule of law will always be the guide. Thank you very much.
Thank you so much. So I just want to start touching on a bit what the stuff you've been talking about just now. Contrary to top judges' remarks in the past, Chief Executive Carrie Lam has previously stated that Hong Kong has an executive-led system of governance without the separation of powers. The Hong Kong Bar Association said that the leader's claim was inconsistent with existing constitutional and legal frameworks of the city. Do you think Hong Kong's system, as it stands, allows for this kind of separation of powers?
Now, the term separation of powers has been used a lot recently, particularly in Hong Kong. It has become a political debate. And it's not healthy for me to engage in a political debate. What is, however, important is when you're talking about the three branches of government, the executive, legislature, and the judiciary, and also terms like executive-led government, so on, are political concepts. I'm concentrating on what the role of the judiciary is, whether it is under the constitutional document, which I described, that is the basic law. Is it independent? What are its functions? The functions under the basic law for the judiciary are, not surprisingly, to be responsible for exercising independent judicial power. So that is the way to look at it. If you want to look at the other two branches, the legislature and the executive, you would of course then look at the legal infrastructure, in our case the basic law, to see what the roles are. So rather than engage in a semantic debate or a political debate, I would far prefer that people can concentrate on just what it is that the three branches of government do. And I'm, of course, particularly concerned or only concerned with the judiciary.
Yes, so the judiciary system is evidently shaped by Commonwealth foundations in law. Do you think the system will change its makeup in the coming years? Or in other words, do you see the judicial system changing in parallel to Hong Kong's governance?
Well, under the basic law, the system of law we have in Hong Kong is a common law system. Now, whether you like it or not, whether you can debate whether you like it or not, is quite another thing. That is the constitutional setup and the constitutional requirement. Now, your question is whether the system, as we know it, will continue. Well, it is the system we have in place in the basic law. A common law jurisdiction like Hong Kong, like any other common law jurisdictions, have to adapt to changes. And of course, change is good if one is looking ahead and making some progress. But it remains a common law system together with common law traits. Now, it's easy to say that because then it begs the question, which gives rise again to probably another talk, which is what are the facets of a common law system? I mean, let me give you one example or one facet or important characteristic of the common law system. And it is this, that everybody talks, in terms of, if you ask a lawyer, what's the one characteristic of a common law system that marks it or differentiates it from other systems? And people will say the system of precedent. What it really means is something I touched upon, which is all courts are required to come up with a reasoned judgment. And this is one of the hallmarks of the common law system, not just to explain to the parties in a case why somebody has won or somebody has lost, but perhaps more important on a general scale, to be explained to the public, because judgments are made public, to explain to them that only the law has been applied in arriving at a result and not any other factor. And for example, if you don't have a reasoned judgment, but simply a judgment saying, for example, Julia, you win, or Julia, you lose, you can speculate then what has driven the court to arrive at that decision. This is where you have potentially unhealthy speculation. So the importance of a written judgment is there for people to see. That is one facet of a common law jurisdiction. Whether it lasts, and I have confidence and hope, I haven't got a crystal ball, but I hope it will last, because if it is shown to be a system that works and works for the community and does its job and delivers the goods, as it were, there is no reason why that system should not remain.
Maybe we can speak to something more specific. The Final Court of Appeal in Hong Kong uses a list of non-permanent judges from other Commonwealth jurisdictions, including Justice Hale, who actually spoke at the Union last year. Let me ask a couple questions about this practice. Has your experience working with judges from other Commonwealth nations shaped your own views of the law? And will the need, or at least the use of these Commonwealth judges, decrease as Hong Kong's own institutions develop and become more independent?
The role of the overseas judges from common law jurisdictions, they're called non-permanent judges as opposed to permanent judges, they make a significant contribution to the court. They are not therefore any form of window dressing at all. What they are here to do is to add a dimension, significant dimension, to the court and the work of the courts. I emphasize the fact they're not there for window dressing. They're there to help, as part of a panel of 5 judges, deal with cases, some of which are extremely difficult. Because of their expertise and experience, of course, they have added a lot to the jurisprudence in Hong Kong. I think all of us, and I certainly speak for myself, have benefited from sitting with these judges. At the moment, we have one from the United Kingdom sitting with us, and that is Lord Hoffman. And he's been sitting with us. And next month, or rather in January, we shall have Lord Neuberger, the former president of the United Kingdom Supreme Court. Now, in relation to your second question, which is, do I see it diminishing or the same or increasing as the years go by? Again, no crystal ball. I see no reason why not. We have recently appointed another judge from the United Kingdom, and this is Lord Hodge, who is the deputy president of the UK Supreme Court. The president, Lord Reed, is also one of our judges. My fervent hope is this will continue because there is a job to do, and they add a significant dimension to the work that we have to do. I stress here again that this is not some sort of political window dressing or anything like that. They are here to do a job. The reason why we had this concept, by the way, historically, of having non-permanent judges sit is that prior to the 1st of July 1997, the final court for Hong Kong was the Privy Council in London. So the theme of continuity in the basic law was that obviously we couldn't have London housing the final court for Hong Kong post 97, but the final court had to be here in Hong Kong. But the contribution of having an overseas judge from a common law jurisdiction was seen to be invaluable. And that's what it has proven to be.
It's very interesting. I didn't know the history behind that. As a member of the Working Party on Civil Justice Reform, you've done incredible work aimed at lowering legal costs and improving access to justice. Do you think a judiciary system can work properly without equal access to justice and representation? And if the answer is no, would this mean that the majority of judiciary systems around the world have some inherent flaw?
Well, I start on the basis that, of course, we have various objectives. One of the objectives of the civil justice reform was to ensure better and greater access to justice for those who can't really afford it. Because litigation, I can tell you, and you know this already, is expensive and beyond the means of many people. So it is, the courts can't just solve everything in one fell swoop. But it can make itself more efficient so it enables greater access to justice. Now, this is an unending battle. Perfection is unattainable. There will always be difficulties experienced by people who don't have access to justice in the sense of not having legal aid. Hong Kong's legal aid system, much criticized, is actually probably better than most, but that's not to say it solves everybody's problems. So there's still quite a sizable number of litigants who are unrepresented. And they are, of course, seriously disadvantaged because the law is not so simple. It's not a simple yes or no answer. It is actually quite involved. So this is something any, I think, respectable jurisdiction has to deal with, but it is extremely difficult. Now, you say, and if a system can't provide full access for everybody, has it failed, is a slightly loaded way of putting it, because if you put it that way, I think every judiciary you can think of has failed. But that doesn't stop. I think judiciary is doing their best But it's a lot to work to do. I can guarantee that to you.
Hmm. In the past, a lot of companies have taken their commercial transactions overseas, like in England and America. As Hong Kong develops its own legal institutions, though, do you think that more of these commercial transactions will be done at home?
Well, a lot of transactions are in fact done in Hong Kong. A lot of transactions which involve commercial ventures all over this part of Asia, particularly within China, involving mainland businesses. A lot of the work goes to Hong Kong. As far as the courts are concerned, for example, in arbitration, in the courts, as far as the courts are concerned, the plus part, let's say, is that I think sufficient people have some confidence, let's put it this way, in the legal system that they wish to litigate here. The downside is that too many do so. And the result of that, of course, are delays in litigation and so on. But commercially, a lot of transactions are based in Hong Kong. Well, one example of this is the proliferation in existence of so many international law firms here, whether from the States or from the United Kingdom. They're all represented here, and they wouldn't be here unless there was sufficient work. But what is important, of course, and as everybody tells me, and you can well believe it, is that if you have in the background a jurisdiction which respects the rule of law and has a decent system of law, that is essential for business. I mean, it's a matter of common sense. A place without the rule of law, where laws are arbitrarily enforced or obscure and so on, it's not going to get the confidence of the commercial community or indeed any community.
Mm. The courts are heavily shaped by the people in them, and I imagine when you were appointed, many of your peers were partially educated in the UK, like you were yourself. Does that hold true of the current generation of judges and lawyers moving up the ranks? And if not, do you think that it has noticeable impact on the interpretation of the law and the principles under which the courts operate?
The answer is that there are now fewer people who would study law abroad, except perhaps on a postgraduate level, because if the rules are such that to enter into the profession, either as a barrister or as a solicitor, if you have not studied in Hong Kong, then you have to take extra exams. So most of the lawyers now are homegrown. That said, the content of the teaching of law, as well as the method, follows what has always been in England and Australia and so on. So there's very little difference. So in terms of the approach, and this is the important part of dealing with cases, eventually, of course, lawyers become judges, or some of them do, and the approach is exactly the same. I of course encourage people, if they can, to study in England and elsewhere, because there you do have your horizons broadened. So, I mean, if somebody has a place in Oxford, I would say, go for it.
You're stepping down from your position in the new year once you reach the age of 65, so I'll say early happy birthday. You'll be replaced by Justice Andrew Chung. How do you think his approach will differ from your own?
Well, I mean, you have to invite him to speak to you, but I am, my own thinking, I'm confident that he would, well, we all have our different styles, but fundamentally, I would expect Justice Chung to understand the rule of law and those aspects about the rule of law I have talked about. And talking to him and listening to his speeches, I see little difference. There will be, of course, a difference in style. It'll be sooner than you think. You're right, because my last day is January the 10th. So I can't calculate, but it's probably a little over 6 weeks or 7 weeks to go.
More trivial question, but do you have any fun plans for when you step down?
Well, I'm very limited in what I can do. I'm not going to go into business, obviously, that's inappropriate. I can't return to practice. I haven't really thought about what I'm going to do. I will do once I retire. I had rather hoped in my final year to have a rather easy goodbye year, but it's turned out to be probably the busiest year I've had as Chief Justice. So I shall, on January 11th, I shall sit down and start thinking about what I'm going to do. I'll be doing something.
Well, I wish you the best for whatever you decide to do. Let's move on to our audience questions, just because we have quite a few. So first, we've got a question from Ben from Keeble. He says, I'm sure you've seen many highly influential cases in your time. What was the most impactful case that you have presided over?
Well, these are, I think it is difficult to point to one or two cases and name them. But what I would say is that the more important, they were interesting, but the more important cases, meaning important for the community as a whole, would be the constitutional and public law cases. In fact, just yesterday, we finished a 2-day case dealing with the constitutionality of the anti-mask ban, which had been passed in Hong Kong. People were forbidden to wear masks during assemblies. There are other cases not dealing with political rights, but rights, same-sex rights, for example, were important. So all those cases were memorable and important, but it would be the constitutional public law ones, which for me would be the more memorable and important.
So we've got a question from Claire who says, how has COVID affected the courts in Hong Kong? Has it been impacted as much as it has in other countries like Australia and the UK?
Oh, definitely yes. Because like in the UK and in Australia, it is at one stage, it simply became not feasible nor safe from a health point of view to have so many people gathered in one courtroom. Now, since the position has improved somewhat in Hong Kong, we have resumed having cases heard in court, but equally, we also hear cases remotely by video conferencing or in the Court of Final Appeal by Zoom. In the Court of Final Appeal recently, we've done this by Zoom because our overseas judge, one from Australia, on another occasion from England, not been practical to fly out. So we've had to sort of organize it by Zoom or by video conferencing. Easier for Australia because that's just 2 or 3 years ahead. England, less easy because you're 8 hours behind.
This is a follow-up question for me, but do you think that that has impacted the results that have come out of these cases in any way?
They should not. It is more desirable, obviously, to have everybody in the same room, but you get used to doing it by Zoom or video conferencing. However, in one type of case, you've got to still have it in court and not doing it by Zoom. And this is where you have witnesses. And in particular, in criminal cases, it is essential that everybody's in the same room and not all over the place, because there you have a jury, you have the defendant. The defendant should be in a position always to come face to face with witnesses, particularly witnesses who are giving evidence against that defendant, saying, you were there, you did it, and so on. It is important that is not done remotely by Zoom and so on.
We've got quite a long question from Daniel from Keeble, so bear with me.
Daniel again.
You've been a big supporter of impartiality in the judiciary system and have come under fire recently for some of the statements you've made this summer when you warned that expressing unnecessary political views threatened to erode the public's faith in the legal system. You were, of course, specifically referencing when District Judge Kwok's compared the protests to a terrorist army in his ruling. I was wondering if you could speak to this and maybe outline the legal philosophy that underpins these decisions.
It's not the decision itself, because the decision itself, whichever way it goes, whether it was an acquittal or a conviction, In the case you mentioned involving that particular district court judge, it was a conviction. It's not so much the result, because the result, if it is wrong, can be the subject of a review or an appeal, and there the usual course, it takes its usual course. Where I have commented is where the judge, in the course of giving reasons for judgment, or in the course of a judgment, has said something which, to be honest, is unnecessary to be said. But once you say it, it gives the impression to people that the judge is politically biased in demonstrating undue sympathy, or in some cases hostility to some points of view. Immediately these are seized upon, often rightly seized upon, to say, well, how can he be hearing these cases, he or she, because you've expressed an opinion which shows your disdain or your admiration for people of a political leaning. Now, that's what worries me, because a judge, as I mentioned, just deals with the law. Political views, political biases simply don't come into it. And when a judge displays that, then there is a justifiable criticism that can be made in relation to the next person who is on trial, to say, well, in your last case, you expressed pretty strong views against people who are of this political leaning or that political leaning. I don't want you to sit because you have given what we call in the law an apparent bias against people like me. And so that is an important part of judging, that you stick to the law and not say anything that reveals a prejudice. It could be a racial prejudice. It could be a prejudice against women. It could be a prejudice against certain religious or political beliefs. That's why it is important for judges at all times not to be actually neutral, but also appear always to be neutral. And that is fundamental. That's why I've been speaking out over the course of this year and criticized for it, because people of the opposite political views says, why are you criticizing judges? He's saying the right thing. Of course, the next day, you'll be saying, why are you not criticizing these people? Or, it depends which political views you are. That is why I've always emphasized it is wrong, fundamentally wrong, to politicize the work of the judiciary. But this is something which does happen from time to time.
So we've got quite a related question actually from Rachel from Merton College. She says, Hong Kong has obviously entered a period of political turbulence, but as you've previously mentioned, it is imperative to maintain some form of stability in the judiciary system. How does one keep Hong Kong's courts impartial while ensuring public confidence in the judiciary system is kept high?
Well, many things are outside my control, outside the control of the judiciary. Politics is one. Political debate, political actions, what goes on, not controllable by the judiciary. What is controllable is what we do. And in order to have public confidence, it's a good point you raised, Julia, because you mentioned the word confidence, and that is essential, because no point having a great legal system, great judges or whatever, if the public ultimately does not have confidence in it. Now, how the public would have confidence in it, I believe, is not to have a biased judiciary, which for certain groups will say, yes, I will deliver to you in, I will always convict these people, type of people, or I will always convict these people, or I will always find for the government, or I will always find against the government. How you earn the respect and therefore the confidence of people is to adhere to what the basic law requires of you and what your judicial oath requires of you, which as I've mentioned, requires you to be neutral, to treat everybody equally, and this includes the government, and to apply only the law. Now, doing that in these political times, as Rachel rightly points out, politics is increasing in Hong Kong almost every day, is while other people enter this sort of debate, the courts must adhere to their principles and just do the right thing, even though this involves severe criticism from high or low.
Mm. So we've got another question from Exeter College. It's an anonymous question. They ask, what is something you wish you could have done as Chief Justice of Hong Kong that you weren't able to do?
Oh, that's an extremely good question, which I'll answer it this way. There are many aspects of the judiciary, the operation of the judiciary, which I would hope I could have achieved, but it's pie in the sky, such as in having an efficient, totally efficient justice system without all the excesses and expenditures, and also having everybody having good access to justice and so on. These are unattainable, but you always leave office, I think, thinking, well, I just wish more could be done. More important than that is that what I hope to have achieved is a maintenance of the concept of the rule of law. Now, by the numbers of people who criticize the courts, obviously not everybody would be pleased with what the judiciary has done. But I hope that everybody would at least respect what the judiciary is trying to do to adhere to those principles which I have just mentioned to you. So if you say what I hope to have achieved, I hope to have achieved more people thinking along those lines than exist, because I don't know what the proportion is, but I'm sure more people could be convinced.
So we have one more question from Edward from LMH College, and he has a very open question. He just wants to know where you see Hong Kong in the next 10 years.
Gosh, that's really hard. Definitely need a crystal ball for that. I am optimistic that people will see sense. I'm not talking politically, not talking economically. I'm just talking from a legal point of view, that I hope and expect that people will see the judiciary, look at the legal system, and appreciate for what it is, which actually, to put it in a nutshell, it's a simple thing to say, which is, it is there to deliver justice and to do so fairly, and everybody is treated fairly before the courts. I mean, that is the ultimate and simple ambition. And I only hope that people will realize that. And in the next 10 years, I hope that more and more people will understand that.
Mm. Well, thank you, Chief Justice Ma. I hope you enjoyed this interview, and I hope that we will one day be able to have you in person in the chamber.
Hope so too. Thank you very much, Julia, and goodbye to everybody.